Guys. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. This is Monday, May 5th, 2025. I am Sabita Singh. To my right is Justice Andy D'Angelo. To my left is Justice Chris Hodgens. We will be your panel this morning. We will be calling the first case of the morning. I just want to remind the parties that this is a partially impounded matter, so to the extent that anything is impounded, make sure not to reveal that during oral argument. And I'll ask for the appellant to please approach.
Good morning. May it please the court, Rebecca Kiley on behalf of Neil Tom. Mr. Tom is a black man who presented two distinct and statistically significant analyses that both showed that he was likely stopped by Boston police because of his race. The totality of the circumstances of this traffic stop only served to corroborate that inference. I would like to address the statistical case, including the Commonwealth's failure to rebut it, and then turn to the totality of the circumstances analysis. As this court knows, in Commonwealth v. Long, the SJC explained that the burden on defendants attempting to establish a reasonable inference of racial profiling had been set too high. The court explained that the way that judges had applied the reasonable inference standard was too demanding, and that the evidence need not be conclusive, the inference need not be inescapable, and a pattern of conduct could be established even with evidence that was not statistically significant. But the SJC also said that Mr. Long should have won his case on the statistical analysis even under the old standard, the old higher standard of Commonwealth versus Laura. And here, the statistical case is even stronger than it was in Commonwealth versus Long, because we have a very similar comparison of the relevant residential census data to the officer's citation data. And in addition, we have something that we did not have in Long, which is an internal benchmark, which compared the officer's stops of black drivers to all of those stops made by other Area B3 officers. And both analyses found real evidence of racial discrimination. Specifically, when the defense expert compared the stops that were made by other B3 officers, what percentage of them were of black drivers, they found that it was 69.6% of black drivers of traffic citations issued by B3 officers were given to black drivers, whereas Officer Monzon issued 83.1% of his traffic citations to black drivers. And the expert found that the probability of that happening at random is 3 in 1,000, highly statistically significant. And when you compared the stops of black drivers that were made by Officer Monzon to the relevant residential population, the adult population of Area B3, which is 65.6% black, that disparity got even starker. The chances that that would happen at random were 1 in 1,000.
Let me ask you this, because we can really get into the weeds on all this data, but the judge wasn't bound to accept the expert's opinion, right?
Well, the Commonwealth was bound to disprove it, and they didn't do that.
Well, but the Commonwealth is not required to meet an expert with an expert, right?
Right.
Okay.
But the Commonwealth is required to disprove the inference of racial prejudice, and they didn't do that here.
But that can be done based on the facts and circumstances that are drawn out at the hearing, correct?
Yes, I think that this court's decision in Commonwealth versus Stroman establishes that a totality of the circumstances analysis could rebut a statistical showing of racial discrimination. But what I do want to emphasize before getting to the totality of the circumstances is that the Commonwealth's rebuttal burden when it comes to the statistical case is not to do what they did here and what the judge did here, which is to merely poke hypothetical holes in the statistical presentation that the defendant made. Rather, they have to actually account for the factors that they claim are missing variables and show that when they are accounted for, they explain away the inference of racial discrimination. And they didn't even attempt to do that here. And I don't think that would always require an expert. For example, in Commonwealth versus Laura, there was a defect in the benchmark data itself, right? The stop happened, I think, by a state trooper on a stretch of I-295 that went through the town of Auburn, and the defendant attempted to argue that the driving population was best represented by the population of the town of Auburn. And that was just patently inapposite. We don't have anything like that here. And I think when it comes to a missing variable, which is what the Commonwealth attempts to say over and over again here, right, that perhaps if she considered the length of the officer's shift or the fact that some of these stops were made during the pandemic, that maybe that would have made a difference. That's not their burden.
But here's the thing, though. All that you're saying could be true. All that the expert is saying could be true. And maybe there is a past pattern.
Right.
But the question is, what happened on this particular day? So even if there was a past pattern, it may be on this particular day that the officer was actually enforcing the law.
Yes,
right? Isn't that a possibility?
That could be the case, and I think that is what the judge concluded here. I think if we look at I'm just going to turn the court's attention to the bottom paragraph of Addendum 47, which is where the judge concludes that the totality of the circumstances here proved that the stop was not racially motivated. So it's just that one short paragraph on the bottom of Addendum 47. The judge relies on 3 factors, and all of them are in direct conflict with what Long says. First,
before you get to that, I want to jump to the end of the Long analysis for a second. Does the judge and ultimately us in this situation have to conclude, in order for you to win, that the defendant was stopped because of his race?
The defendant has to raise a reasonable inference that he was stopped, at least in part, because of his race. If the Commonwealth fails to rebut that reasonable inference, which I submit is what happened here, then the defendant wins.
So why can't we take the finding of the judge here that the officer, he said he didn't remember if he could see the color of the defendant before he stopped. But what if the judge finds that he didn't see the color? Does that end the case?
Well,
And she credits that testimony. Does that end the Long analysis?
I think under Stroman, if as the officer testified in Stroman, he could not and did not see the race of the driver, then yes, I think that would end the analysis, unless there were Long and Stroman both allude to the possibility that targeting a particularly minority neighborhood could still give rise to a claim. But in the absence of that kind of argument, yes, I think that would be dispositive. But that is not the case here. What the judge relied on is, what she said was that the driver's race or skin color did not stand out to Officer Monzon. And first, I don't think that's actually his testimony, which is, as you correctly stated, that he just couldn't remember whether he noticed the driver. But the factor that Long...
Isn't that the same thing? Or at least the judge could interpret it that way based on credibility?
Possibly. But the factor that Long sets forth, and this is in footnote 9, is whether the officer had the opportunity to observe the defendant's race. And here the evidence was clear that he did. Officer Monzon testified that he perceives Mr. Tom to be a black man and that he is a black man, and that they were passing each other, traveling at normal speeds on a 2-lane road on a Saturday afternoon. He clearly could have seen the driver. And the reason that Long makes that the factor and not whether the officer thinks race stood out to him is because they recognize that implicit bias can cause an officer to make a stop based on racial discrimination without even being aware of it. In fact, Long says that at 7:20 and at 7:31 and at 7:34. And they explain that
But was there testimony that he actually saw the driver? Because I was looking for, there were references to photographs and so forth and exhibits, but I didn't see any in the record here. Like, was there a tinted window? This was a...
There's no evidence that the window was tinted. I think...
Was there evidence that it was not tinted? I mean,
no, but again, the Commonwealth has the burden of proof.
There was no evidence on whether or not he could even see the driver as he's going by, because they're going in the opposite direction, right?
They're passing each other,
Right.
facing each other.
So he
And there's-
sees there's a missing registration plate,
Yes.
but there's no testimony that he could see who was in the car, right?
What he testified to was that he couldn't remember if he saw the driver. And then I think defense counsel did a very careful and thorough job of establishing that he definitely had an opportunity to see the driver. And I don't think any testimony was specifically elicited about whether the windows were tinted, although perhaps there was evidence that they weren't, I just don't recall. But again, the Commonwealth has the burden to prove the totality of the circumstances, rebut this case. And they certainly didn't introduce any evidence that the windows were tinted such that he wouldn't
Well,
have
let
been
me
able
tell
to
you
see the
something
driver.
that struck me as kind of important, and see what you think of it. If the theory here, your theory is correct, that it was racially motivated, you would think a stop would have occurred right away, but instead, they drove past him, made a U-turn, and came up behind, and I thought this was very interesting, to verify whether or not it was a green registration plate or a red registration plate, the green meaning you don't need the front registration plate, the red meaning you do. Why would you do that if you were racially motivated?
Well, for two reasons. One is, I don't know how an officer would make a stop on a two-lane road without doing a U-turn and getting behind the
But
driver.
it wasn't just that. It was to, I believe the testimony was
Yes, I
to
know he
verify
testified to that.
what color the registration plate
Well,
was.
because I think the officer knows he has to have a valid basis for the traffic stop, and he doesn't have it until he sees the color of the license plate. And there are other circumstances here that point to, I think, a non-traffic related motivation. One is the fact that they immediately frisked Mr. Tom after learning that he had a suspended license, which is just not, it was illegal. There was no reason to believe that he was armed and dangerous. Two, and this is also something that I think the judge mischaracterized. She said the officers were assigned to patrol their district enforcing the traffic laws. But what their testimony was that while they could make traffic stops, their primary duty was that they were assigned to a rapid response car, primarily designated to handle serious calls for violence. And what Long says in footnote 8 is that the court should consider whether the traffic stop was initiated by officers whose primary assignment does not involve the enforcement of traffic laws, i.e. the kind of assignment here. And then in addition to that, Long also says that you should consider the safety interests in enforcing the motor vehicle violation. And Long gives us an example, right? If an officer makes a stop of somebody going 100 miles an hour in a 65 mile an hour zone, or I'm sorry, that example is from a footnote in Robinson Van Rader, that if they make that stop, that's clearly a safety stop, and it's going to go a long way, I think, towards rebutting a claim of racial discrimination. This is not a traffic safety issue, right? This is a pretty minor motor vehicle violation that is not among the priority, the priority offenses that are targeted by Boston police.
But how, that seems, I mean, how so much of policing is discretionary, especially when it comes to traffic enforcement.
Yes.
I mean, how should we kind of get into the weeds on that to determine whether or not, I mean, for example, a day like this, a rainy day, if you get stopped by a police officer, it's a pretty good bet you're going to get a ticket.
Right.
Right?
Well, yes.
But a beautiful sunny day, maybe not. I mean, there's so many variables that go into it.
Of course, but I think the lesson of Long and Robinson, Van Rader, and maybe Sturman, is that the more discretion the police have, the more worried we have to be that they're going to exercise that discretion in a biased way, right? This is, this is the problem, is that, the more discretion they have, the more likely they are to stop people because they are black. And actually, the defense introduced a study of Area B3 officers that found that more than any other area in Boston, the disparity between found a really heightened disparity between stops of black drivers and stops of other drivers. The more discretionary the stop was, the less it was, for running a red light, running a stop sign, excessively exceeding the speed limit. The more discretionary, the more discrimination. So we have to be worried about that, and Long asks us to look at that. I think it's also important to remember that the totality of the circumstances analysis was put forth in Long as a way for a defendant who couldn't make a statistical case to nonetheless prove that he had been the victim of racial discrimination. And while I recognize that in Stroman, this court said it can also rebut a statistical case of racial discrimination, more is required than what we have here to do that. You've got to put forward a pretty strong case that this is this is a serious violation. Another officer would have made this stop. I don't think.
Well, is that what it says? That it has to be a serious infraction, or does it have to be an infraction that the officer normally doesn't make, except for the fact that the driver is not a Caucasian? Isn't that what it gets to?
Well, perhaps, but I think that would also weigh in our favor here. The Commonwealth tries very.
I would agree with you, except for the testimony, quote, a lot of stops. He makes a lot of stops for failing to have a front license plate.
Yes, and I think we can argue, and we did in the briefs, about whether the evidence actually supports the judge's finding that he made 50 stops for failing to have a front license plate. However, if he did, what Long tells us, and Stroman says the same thing, is that we can assume that an officer who issues traffic citations in a racially disparate way is making stops in the same way. So if he stopped over 50 people, we know over 40 of them were black. And the fact that this officer is repeatedly targeting black drivers for a low-level traffic offense does not rebut the defendant's case. It just serves to prove it. I think the defendant put forth a strong statistical case, and it is only confirmed by the totality of the circumstances here. The Commonwealth did not meet its burden to rebut the case. I see that my time is almost out. If the court has no further questions, I would ask you to reverse the order erroneously denying the motion to suppress, to vacate the judgment of guilty, and to order judgment for the defendant. Thank you.
I have just one more question.
Oh,
You
sure.
mentioned that there's evidence in the record about the opportunity to observe the operator's race. And where would you point to the strongest evidence of that opportunity?
I would have to consult my brief for the record sites, but there is a whole section of the defendant's cross-examination of Officer Monzon in the May 6th transcript, where he asks a number of questions, including actually going so far as to ask whether Mr. Tom's car was a standard American car and not a British car where his steering wheel would have been on the other side, but where he establishes that they are, that it's a Saturday afternoon, it's a two-lane road, neither of them is speeding, they pass each other. And that factor is in Long at footnote 9.
And are there findings on the opportunity to observe?
I think the judge only makes the finding that he, she generally credits Officer Monzon's testimony, and this is drawn from Officer Monzon's testimony. I believe that her finding is simply that he could not recall whether he saw the defendant's race. And again, that is different than the testimony in Stroman, which is that he could not and did not see the defendant's race.
Thank you. Any further questions? Thank you.
Thank you.
May it please the court, ADA Bryn Morse on behalf of the Commonwealth. So here, there are 5 factors that show that the Commonwealth successfully rebutted the inference of racial profiling. First, that the officers were out patrolling for traffic violations. Second, that the officer noticed the violation first and wasn't out running random plates. Third, that this was his usual race-neutral practice of pulling people over for this type of offense. Fourth, the seriousness of the offense. And then fifth, that post-stop, the officers, after discovering that the defendant was driving without a license, chose not to arrest him on that offense despite having legal justification to do so.
Can I talk about number 4, which you just said, the seriousness of the offense? Where in the record does the judge's finding that a lack of a front license plate is somehow connected to a stolen motor vehicle? Where in the world did that come from in the testimony or the record that she had?
Your Honor, that did not come from either of the officers. It appears that the judge mentioned that, presumably based on the judge's experience with this type of offense.
And is that permissible to make a finding based on her experience, I guess, as a trial judge in other cases, to make a finding of that in this case, when there's no evidence of it?
I think, Your Honor, that it is a reasonable conclusion based on somebody's life experience, kind of separate of whether or not they're a judge. And I think the seriousness of traffic violations are inherently measured based off of people's experiences with what those traffic violations imply. I mean, the same way that you wouldn't have an officer testify.
Counsel, I was a trial judge for a long time, and so was one of my colleagues here. I don't think I would ever be able to make a finding that the fact that there is not a front license plate is somehow connected to a stolen motor vehicle. And if there is nothing in the record to support that, I don't see how we can say that that was not an erroneous finding. Which gets to the second part of why is not having a front license plate, I think number 4 was the seriousness. How is that a serious motor vehicle infraction?
I think, Your Honor, it's common sense that the reasons why somebody wouldn't attach the front license plate is because they're attaching it to another vehicle and not registering that other vehicle. There's not really any other common sense explanation for that. And whether that means that it's a stolen vehicle or simply that they're not paying a second registration, either of those mean that there's a vehicle basically unaccounted for. And the officer—
Do you have any legal support that says we can make that connection somehow without any basis for it in the record?
I don't have a specific case site on that, no, Your Honor. I think that based off of that information, in the same way that an officer wouldn't get up there and testify, the reason why we consider driving 20 miles over the speed limit is dangerous is because it's more likely to cause crashes or make the crashes more serious. In the same way that an officer wouldn't testify necessarily to all that background information unless challenged, the officer does not have to testify to all this background information without it actually being challenged here. But regardless, even if that wasn't a factor, the 4 other factors are still enough to rebut the inference of racial profiling. Long discusses this and discusses what the statistical evidence shows and doesn't show, but what Long is mostly talking about is that the judge erred in not finding that the defendant met the defendant's initial burden of showing racial profiling enough to trigger the Commonwealth having to rebut that. Statistical evidence is not infallible and it doesn't need to be directly rebutted. And I think that's very well explored in Robinson Van Rader. And here, the circumstances sufficiently show that this was the officer's race-neutral practice of pulling over for this type of offense. And that evidence alone is enough.
Let me ask you about something that happened during the stop that concerned me. So when they make the stop, he pulls over right away, apparently pulls into what's designated as a bus stop. And when they make the decision to apprehend him, they decide to tow the vehicle because it's now parked in a bus stop. But that's what, I mean, the police were responsible for that. And I was thinking of that myself, like, boy, especially in Boston, I don't think there's any place you can go without being in a designated bus stop, bus lane, bike lane. I mean, we could all get towed, based on that. So that seemed a little bit odd, didn't it?
No, Your Honor. Most of the time when you're stopped pursuant to a traffic infraction, you then can drive your car away. Here, the defendant could not drive his car away because he was driving with a suspended license.
Okay, well, that leads to my next question. Why couldn't he have had the opportunity, and apparently his mom did show up eventually, but why couldn't he have the opportunity to have somebody else come and just get the car?
So,
put the plate on it, right? Because he had it. He did have the plate, so just put the plate on it and drive it off. It almost seemed like a bit of a pretext to inventory the car, didn't it?
So, Your Honor, that's not challenged on appeal. And
I know. It kind of fell by the wayside for some reason, but I'm just saying that's what bothered me about this when I read through the materials.
I mean, yes, Your Honor. It's generally considered, I mean, the officers are supposed to give a defendant an opportunity to call somebody to
and they didn't
come.
He should have been able to drive that car away, or someone should have been able to drive that car away, right?
Perhaps. Generally, I believe the legal requirement is that if the defendant says, or if the defendant has a passenger or says that they'd like to call someone, that might trigger that. But where it's stopped in a bus lane, it also shortens the amount of time where it's reasonable for the car to be parked in its location prior to somebody arriving. And here there was no other passenger to turn the car over to. I think that based on those circumstances, this was a reasonable decision for the officers to make, particularly in light of the fact that they chose not to arrest the defendant based off of the fact that he was driving with a suspended license, even though they could have, shows that they were not exercising the full force of their authority here, even their legally justified authority.
Was there any evidence as to whether or not the police knew the race of the mother when she showed up?
So there's no mention of the race of the mother when she showed up. We're not heavily relying on the fact that they chose not to penalize her, in part because of that, and in part because the other circumstances of the stop, I think, are stronger, and they alone rebut the inference of racial profiling.
Might have been helpful if we knew that, though, right? I mean, because it looks like they gave her a break.
Yes, Your Honor. Yes, had we known the race of the defendant's mother, that could bolster the Commonwealth's case here, yes. So I want to address the first point that I brought up, just because it was contested by my sister, about what the officers were out doing. There is testimony that the officers were out patrolling specifically for traffic violations in this neighborhood on this shift. They were out looking for speeding violations, and that weighs in favor of the fact that this was a race-neutral stop, because under one of the long factors that we look at what the officers were assigned to do here. If there are no further questions on the traffic stop issue, I'll briefly address the second issue here, which is whether or not the inadmissible hearsay created a substantial risk of miscarriage of justice. So here, there's two reasons why this did not create a substantial risk of miscarriage of justice. First is that the fact that the defendant did not have a license was in fact corroborated both by the fact that he didn't provide a license to officers during the traffic stop, and by the fact that he provided a Massachusetts identification card. And then second, each element of the crime need not be corroborated. It's sufficient here that there was corroboration of other elements of the crime, namely that he operated the motor vehicle. And if there are no further questions, I'll rest on my brief.
Thank you.
Thank you.
Thank you both. The case is submitted. The next case on the list is 24P911, Commonwealth versus David DELRATEZ. Good morning.
Good morning, Your Honors. Excuse me. May it please the Court. Suzanne Renaud for David DELRATEZ. Your Honors, this is obviously a one-issue appeal, and with one overriding question about whether or not this Court's published prior precedent commands the outcome that's requested here, that he be allowed to withdraw his guilty plea. And the question, obviously, is the applicability of Commonwealth versus Najjar.
Counsel, before you get into your legal argument, I have some procedural questions, and I guess I'm tipping off the Commonwealth because I'm going to be asking her the same thing.
Okay, thank you.
The way this case comes to us, are we supposed to accept as true everything that that plea counsel said in the affidavit, and perhaps more importantly, everything the defendant said in his affidavit? How do we do that?
So this is a very interesting question because at the outset of this, the parties were agreeing that this was a legal question as long as the affidavits were accepted. Judge Agostini said, I am accepting the affidavit and I'm crediting everything that trial counsel said. He was not as clear at all about whether or not he was accepting Mr. DELRATEZ's affidavit. I would say for the first argument, the Najjar argument, and not the ineffective assistance of counsel claim, that Mr. DELRATEZ's affidavit is almost immaterial. Well, I mean, it's not immaterial. It's important to know that he said that he was misinformed. But you know that he was misinformed by crediting counsel's affidavit.
Isn't it crucial for us to know why he pled guilty in a sense?
It is not, actually. So there's.
Tell us why.
I will, Your Honor. I think that under Najjar, they are talking very specifically, and they're rejecting what the dissent said, that materiality is an issue. They're basically saying, in Najjar, that the moment that you know that somebody was misinformed, and that was not corrected, and that is, and we can talk about the merits of that was a knowledge and lack of information intelligence issue. On its face, you basically don't need to go further on the prejudice, any kind of prejudice, because that plea is void. That's what Najjar says. It says you don't have to analyze the reasoning. And even there, if you were looking, if you were looking at this as ineffective assistance of counsel, Commonwealth versus Sylvain says that we have to look at the defendant's reasons, so that is true, but we don't have to look at what a rational defendant is saying, so we do have to look at the defendant's reasons. So the defendant's reasons become more important when you're looking at ineffective assistance of counsel.
I'm not buying it on the first prong that you said. So if, hypothetically, if there had been an affidavit that said, I would have pled guilty whether it was whether I could go to jail for 15 or 12 years. That would be pretty important, wouldn't it?
So it would, I just want to repeat, I'm looking at this, at page 573, as a matter of due process, unknowing pleas are void. So as soon as somebody has established that it's unknowing, it would be void. As a result, I think you could arguably say the court itself could bring this kind of motion. The Commonwealth could bring this kind of motion once they factually establish that the defendant had bad information. So your point, Your Honor, I understand it. It feels uncomfortable because we're used to dealing with this on a prejudice basis. But when you are saying that if you were looking at the very limited information or that Najjar is demanding, Najjar says you don't need to go any further than simply establishing that misinformation on a critical point, that the defendant's personal, subjective and objective, but personal knowledge to the defendant, that they are lacking that information. Once that factually is established, that's the only thing you need to factually establish. You don't need to establish that the defendant had other opportunities or other options or had better options or had other things that they were considering. I mean, those things exist in this case. They weren't brought forward because it wasn't an evidentiary hearing, but they do exist, and it could be remanded for an evidentiary hearing. Najjar was remanded to confirm.
How does that square, though, with other cases? So, for example, in Delicato, inaccurate or incomplete advice from counsel does not automatically render a plea involuntary or unintelligent.
There is a
Supreme Court has said the same thing. A guilty plea must be intelligently made. That it must be intelligently made is not a requirement that all advice offered by the defendant's lawyer withstand retrospective examination in a post-conviction hearing. And just 2 years ago in Commonwealth versus Minan, this court said the same thing. So.
But Najjar, which is, this is very loud today, I'm sorry. Najjar, which is the controlling precedent in Massachusetts, has very clearly said that the length of the mandatory minimum, and not just any mandatory minimum that cannot be reduced any further, is among those things that must be known to it doesn't need to be known. We have a difference here between things that need to be given to the defendant, say Rule 12, you need to give it to them, but prejudice isn't automatic. Ineffective assistance, probably you need to provide that information, but prejudice is not automatic. But when you have a case like Najjar, where there is misinformation on this point, it is settled in Massachusetts that this is such a critical factor of something that needs to be provided, that this is considered to be a direct consequence of the plea. We're not revisiting that. The Commonwealth admits that Najjar is still good law. And so at that point, because we have that established, all of that other case law, Your Honor, that you cite may well be true in other circumstances, but with this particular facet of the plea, it has been determined that if there is misinformation about this facet, that being the mandatoriness of the minimum.
I just want to clarify, what are you talking about in terms of this facet?
It is,
Is it minimum mandatory? Is it good time? Is it parole eligibility? What?
So in this case, when they define in Najjar, when they define mandatory minimum, it's not just the mere fact that, say, Commonwealth versus Onyx White, which is an unpublished case, you talked about larceny having a 5-year mandatory minimum, but that one can still be reduced. In this case, and in some gun cases and drug cases and, say, some rape cases, it cannot be reduced. There is a legal impediment to being able to reduce it. And what Najjar has said is that the mandatory minimum includes the fact of not even having the possibility of somebody earning that good time credit. So that is what is specifically being required. So if you had a case where, say, a slightly just different situation from Najjar, and somebody had a drug case, and it was, they were getting an 8 to 10 year plea, 8 to 9 year plea, but the judge only said, you're getting a 10-year sentence, and just left out the minimum altogether, then that would fall within Najjar. But what also falls within Najjar is, in Najjar itself, they said, you're getting an 8 to 10 year plea, but he had no idea that that was a set in stone amount. There are a few kinds of cases where the law says this is not only the minimum, it's not only mandatory, but this is not going to fluctuate, it's not discretionary, it's not based on how you behave when you're in the prison system. It is absolute. And what Najjar has said is that if that facet of the plea is there is personal misinformation to the defendant, that's the end of the story. That's enough to say that the plea should be declared invalid as a matter of due process. It's an unusual situation. It's not the type of thing that we see very often. Usually you're looking at these things in the terms of ineffective assistance of counsel, but that is not what this case is. And that's not what Najjar is saying it would be.
So you are looking at this as a minimum mandatory case?
It is a minimum mandatory case. There is a regulation that is the force of law that the judge needed to incorporate in saying that this is the minimum mandatory. And not only the judge, his trial counsel needed to incorporate that as part of the minimum mandatory. And maybe in a different case, if neither one of them said it, it wouldn't matter because we'd be looking at this in a different procedural posture. But in this procedural posture, because the misinformation came from one source about that being reducible, potentially, and so now he has hope to reduce it, from his trial counsel, and literally nothing on the plea record, hearing record, changed that.
Well, what about this exchange here on page 59? Well, it's 34, the transcript, 59 of the appendix. The judge saying, I think this is a fair recommendation, a joint recommendation, by the way, for this particular case. I expect that the defendant may not get out of jail during his lifetime. Mm-hmm. So I will accept the joint recommendation. And then defense counsel says, yes, Your Honor, it is a life sentence.
That's talking about the maximum. That's not talking about the minimum. And I think that there is...
let me finish.
Oh, I'm sorry.
It is a life sentence. The only thing that the law has changed that the court can announce anywhere between 15 to 25 years for eligibility date. So essentially, it's life with parole eligibility at 15 years.
So, Your Honor, I think that this is very similar to what happened in Najjar, which is they are talking about the fact that there is a minimum sentence, which is what they're doing, and they even talk about the fact that that minimum sentence has a fixed number in the plea context. But what is not coming out, and the fact that it's trial counsel who's making those statements that you just read, is that trial counsel also told Mr. DELRATEZ that that 15-year number is flexible. So even though that you're going to hear this 15-year number in court, like 90% of other cases, basically, he said, that number can still be reduced even further.
This is where I go back to, how do we do this without knowing what the defendant thought at the time? Because based on the chronology of what plea counsel said in his affidavit, it was actually the defendant who brings up to him about good time credit. So he actually has some knowledge about the prison system, which frankly is not uncommon with some defendants who plead guilty. So going back to what Justice Hodgens said, when the judge says it's 15, why don't we use that as the judge telling him that's the minimum mandatory?
Because, Your Honor, because before they got to the plea hearing, according to Attorney Green's affidavit, he and his client had had this discussion about reducing it or whether it could be reduced. So this is before he actually, bit the bullet and went in before the judge and everything else. And so his understanding, keep in mind, everybody's talking about how this was new law at this time, so they think that this could happen. His understanding is when he hears the word 15, is that he has some control over whether that could be made shorter. And that's coming not out of his own personal affidavit, that's coming out of counsel's affidavit. I would also say that in Najjar, the defendant in Najjar was also the one who raised the issue. He also had knowledge that good time was something that could affect the length of a plea and when you could get out. And when he was given the wrong information and nothing at the plea colloquy changed it. So the fact that the defendant is the one asking the question.
So we should ignore the part, maybe ignore is not the right word, plea counsel's affidavit where he says that the defendant early on in the discussions regarding the plea says he would take the 15 years.
So
before the good time discussion.
So,
and again, I'm going back to, I don't know how we do this without an evidentiary hearing about what the judge says about credibility here.
So we know that he credited this affidavit. We are certain that he credited this affidavit. What I would say to that, Your Honor, is that the discussions with counsel are going to, bounce back and forth. And he's trying to get it as low, obviously clearly going from 18 to 15, getting it as low as possible. But before he appeared in court, he asked one final question. And that's really, even if Mr. DELRATEZ brought up the 15 years, and if his knowledge of going to prison was that, it says that I have a 5 to 7 year prison sentence. Oh, but that 5 years really only means 3.
Which is, that is exactly what defendants do.
And that's typical. So he asked that one final question before they went in and said, is this also eligible for good time? And his counsel said, yes. And it doesn't matter what the discussion was leading up to that. I mean, it does matter, but it's not the pertinent part. The pertinent part is at that final moment before this whole thing got together, that was the misinformation that he got. And then when you look at the actual plea, nobody says anything different about it. Nobody actually says, well, when I say 15, that means you're locked in at 15. And I'll even give you a little counterexample. If you look at Newman, which I don't think controls in a lot of ways here, but one of the reasons they didn't use Najjar as the primary focus there is because somebody actually said on the record, including, I think, defense counsel, you will not be parole eligible until you hit day 18, the first day of the 18th year. That didn't happen in this case, and so I think that makes this case stand on all fours with Najjar, and I would ask you to reverse on that basis.
Thank you.
Good morning. May it please the court, Lori Levinson for the Commonwealth.
You had a preview.
I had a preview.
I'm coming out of the gate right at you. Do you agree that at this stage right here where we are, we should accept as true what the defendant said in his affidavit?
It's very hard for me to say, Your Honor. And you're right, there was no evidentiary hearing where that allegation by the defendant could be tested, but we do have the affidavit of plea counsel, which the Commonwealth did credit. The Commonwealth is very familiar with Attorney Green, and there was no reason to discredit what he said because, unlike a lot of other affidavits, this was not self-serving at all. He was throwing himself under the bus. So we do credit what defense counsel said, but the defendant himself said very little about what that really meant to him. And I also was noticing.
Well, I mean, he said enough to say that when they were talking about 15, I thought I could get less than that.
Well,
And isn't it fair to say that when defendants plead guilty to something, probably the biggest concern in their mind is, how much time am I going to actually spend in jail?
Well, in a first-degree murder case, which this was, the defendant was given a fabulous concession. He went from a mandatory life sentence with no possibility of parole to his lawyer, after a long series of negotiations as set forth in plea counsel's affidavit, coming back with 18 years. The defendant says no way.
And that might be a prong we look at if we get to the ineffective assistance. But I agree with your sister counsel that we're not there yet. So he may have gotten a great deal, and I agree, it sounds like a great deal, but if he thought, based on his counsel's representations and based on what happened during that colloquy, that he could get less than 15, why is that a knowing and intelligent plea?
Well, during the colloquy, he was probably disabused of any notion that he was getting out sooner than 15 years, because the 15-year number was stated over and again, both by the judge, defense counsel, and the prosecutor.
It's not necessarily inconsistent with good time, being able to reduce that, right? Just the fact that you have a minimum, there's always a minimum, but knowing that good time would not apply, it wasn't necessarily negated by anything that happened in the open plea, right?
Well, during the plea, one of the distinguishing factors of this case from Najjar is that the prosecutor was the one who provided the misadvice. The prosecutor actually told the defendant, you can get out in half the time. Here we have a defendant who was happy with the 15-year bargain that the lawyer came back with. And then the next time they met, I think it was a couple of weeks later, for the first time, the defendant says, oh, do I get good time? And defense counsel says, yes, we have no idea what the defendant thought good time could have meant. I mean, if he was so familiar with the system, he would know that good time is a very contingent type of thing, and that he's not guaranteed to get good time. He's not guaranteed any amount of good time. And
so then are you agreeing that this needs to be sent back for an evidentiary hearing regarding what the defendant actually thought?
I'm not, Your Honor, because in this case, unlike in Najjar, the defendant was told repeatedly during the plea colloquy that he was facing actually a mandatory life sentence. I think it was you, Justice Singh, who asked my sister, are you treating this as a mandatory minimum case? And in fact, it's really not. There's a mandatory minimum for murder in the second degree, and that mandatory minimum is life.
Well, no, that's the mandatory maximum penalty.
It's both the mandatory maximum and minimum.
That's not how we've dealt with mandatory minimums in every other case. In mandatory minimum cases, our court and the SJC have said that the judge is obligated to the plea either by asking defense counsel or by asking the defendant himself what the top number is and what the bottom number is. And that really wasn't done here.
Well, the bottom number was given as 15.
But not as a mandatory minimum. That's the problem I'm having. Again, when I use mandatory minimum, I'm using the language of, where the legislature has said it cannot be reduced by probation, it cannot be reduced by parole, and it has that litany of stuff, which means you're going to serve 15, period. Nothing less than that. That's not what was said here. So how do we treat this as a mandatory minimum at the plea stage when that type of colloquy wasn't given that we've said in other cases should be given?
Well, I think that in this case, the colloquy did comply with Rule 12. The judge did ask plea counsel did you talk to him about the mandatory minimum plea counsel?
Now we know that was not I'll say accurate. I won't say true, but that was not accurate because he actually gave him incorrect advice. He discussed it, but he gave the wrong advice. So how do we say that that is a good advice?
I'm not saying it's good advice.
It was wrong.
It was wrong, and we credit that he gave wrong advice, but we also don't think that it rises to the level of allowing this defendant to vacate his plea.
Let me tweak this a little bit. What if the judge had said, your sentence is 15 years to life, but you might be parole eligible before 15 years. Do you still want to plead guilty? Yes. Would that be a knowing and intelligent plea?
I think so.
Really? So the judge gives him incorrect terminology and he agrees to it, and that would be okay?
I'm sorry, Your Honor. Got it.
So all I'm doing is flipping what the judge said versus what his attorney said. How is that okay?
Because, again, I believe that the plea colloquy cured any misadvice, with the judge specifically stating to the defendant, you may not get out within your lifetime. And the defendant knows that parole is contingent, that there are lots of hoops that one has to jump through in order to get to parole. So there was no guarantee in this defendant's mind that he was going to get out in 15 years. And the judge warned him that he might not get out in 15, 20, 30, 40, whatever. He may be in there for life. And that was clearly explained to the defendant at the time. And I think that the defendant is misreading Najjar as changing this court's jurisprudence with respect to the distinction between direct and collateral consequences of a plea. This court, the Supreme Judicial Court, has steadfastly held that parole and good time are contingent consequences of a plea and do not have to be part of what a defendant knows or has to be told prior to entering a constitutionally valid plea.
But a minimum mandatory must be made clear.
Is a direct consequence, and Najjar actually reaffirms the fact that mandatory minimum is a direct consequence.
So was this a minimum mandatory case?
Yes, it was, but the Commonwealth believes that the mandatory minimum is life, and that parole eligibility is a privilege that the defendant may be able to avail himself of at the 15-year mark.
And didn't the judge address this as well? I mean, you know, these judges put a lot of time into these colloquies, and, you know, they really try to probe all of this, especially in a case like this. And the judge on page 41, the appendix, said, as I understand it, you're pleading guilty because you are guilty and for no other reason. So doesn't that put aside whatever misapprehensions the defendant's operating under, whatever other reasons he might have for pleading guilty? He told the judge he's pleading guilty because he's guilty and for no other reason. So any of these other consequences, aren't they put to rest by just by asking that question and getting the defendant's answer when he responded yes?
I believe so, Your Honor. I believe so.
Do you have any other case or a case that says that that type of answer cures all ills of a plea?
No, I wasn't looking.
Why does it cure it here? If we assume that this was a minimum mandatory sentence, and I know you take the position that life is the minimum mandatory, but we take the position that 15 years is really the minimum, why does the language that Justice Hodgens just said cure that problem?
Because the defendant is saying right there that the reason I'm pleading guilty is because I am guilty. The little footnote, the little balloon over the defendant's head is that I just escaped a mandatory life sentence by being allowed to plead guilty to second-degree murder. And the fact that I have the possibility of seeing daylight again during my lifetime is part of the calculus in pleading guilty, because he is guilty and for no other reason. I mean, the defendant never pipes up during the colloquy. Your Honor, you keep saying it's a 15-year sentence. Mr. Prosecutor, you keep saying it's 15 years. But wait a minute, I think I'm going to be able to get out before 15 years. He never says anything like that. He goes ahead and he says, this is the reason I'm pleading guilty. Yes, I understand what I'm pleading guilty to. I understand, yes, my lawyer told me the mandatory minimum. And he goes forward.
Let me ask you this.
Yeah.
This was a vicious murder, 83-year-old female stabbed and beaten in her own home. Her blood is found on the defendant's clothing. He steals her car. He's found with the car. So it would seem he would have every reason to be looking for a plea based on that. If this plea were withdrawn, would the Commonwealth be prepared to try him for first-degree murder?
Yes.
Could I-
Yeah. No, I don't need to add to that.
Could I just ask you a question on the ineffective assistance
Sure.
issue? Is it fair or appropriate to use an immigration sort of case to use the analysis for this case?
Well, as we know, Padilla was very, very specific as to deportation consequences, which was a complete carve-out from other either direct or collateral consequences. The court was very specific in stating that this is a sort of unique kind of situation. So, but back to the ineffective assistance claim, the defendant would have to establish prejudice, and I don't believe that there's any way the defendant could establish prejudice here. He doesn't say that there could have been a better plea offer. He doesn't state that there was any defense that was available to him that he gave up by pleading guilty. So
Except if we have to accept his affidavit as true, he basically says, I didn't do the crime because he wanted to, he claims, again, if we accept it as true, he wanted an Alford plea.
Well, there is a great reason to not accept his affidavit as true.
I thought we had to. I thought we were taking the premise that we were accepting it as true.
The Commonwealth was accepting defense counsel's affidavit as true. The defendants, not necessarily. You can freely look at that. And what's interesting about him saying, I wanted to take an Alford plea, during the colloquy, one, he says he's pleading guilty for no other reason other than he is guilty, but two, he also apologizes to the family for what he has done, which definitely takes away from the Alford plea assertion that he's suddenly making, 11 years after he pleads guilty. So we do not credit what he said about that one bit. Seeing no other questions, I will rest on our brief. Thank you.
Thank you. Thank you very much, counsel. The case is submitted. The next matter on the list is 24P 717, RITA Battles versus Anthony Tam. Morning.
Good morning. May it please the court, my name is June Barry, and I'm here on behalf of the appellants Anthony Tam and Catherine Newey. This case asks the court to examine the use of a Rule 20 special verdict slip by the trial court which the Mr. Tam and Ms. May allege or assert is a defective form or certainly not appropriate for purposes of what the trial court needed to determine in making the findings that it did.
Did the parties agree to the form?
I'm sorry?
Did the parties agree to the form?
There were two different forms. There was a form, there was originally a special verdict form that was submitted that contained some emotional distress claims that the parties agreed would be, they were waiving those claims. Then a corrected special verdict form was submitted that excluded those claims, but did nothing to address the fact that they're, at a minimum, under Rule 20, these forms are supposed to contain the elements of the claims that are being assessed, and the revised form did not. The fact
Or by agreement, interrogatories to be answered, and that's what happened here, right?
Well, no, I think here, Your Honor, with due respect, I think that the court should have policed this form in a fashion that made sure that the court was doing what it needed to, because the result of this defective form means it's not possible for this court to determine, or anyone to determine, the basis of the court's findings that on the exact same record that it would find trespass and an ongoing nuisance by the Mr. Tam and Ms. Mui, and not a corresponding trespass and nuisance in their counterclaims. The facts, and that means that the facts are not sufficiently before this court that the court can ascertain whether...
So you're saying even if, the alternatives being the elements being listed or the interrogatories by agreement of the parties, you're saying that those interrogatories have to incorporate the elements?
Yes, that is our reading of Rule 20, and I don't see anything in Rule 20 that indicates that those things are separate and distinct.
Can I go back to Justice Singh's question and try to get an answer for?
Sure.
When you say it wasn't agreed to, the original form was exactly the same as the one that ultimately the judge used, except for it took out the emotional distress part, correct?
Yes, I'm not saying it wasn't agreed to.
So if it was agreed to, why hasn't the party waived that? There's no objection. It was agreed to. That was the verdict slip the judge was going to utilize. Why isn't this issue waived?
Because the court should have policed the use of the form. This is the court's rule. And if the parties misconstrued the information that needed to be part of that special verdict form in order for the court to actually issue a verdict instead of going to a jury trial, which is really what the parties agreed to, and they did not, neither of them did.
Do you have a single case that supports your proposition that if there's no objection and it's an agreed to, that somehow we should ignore that because the judge should be doing something else?
I think that it can be found in jurisprudence concerning the court's use of its own rules. This is a Superior Court generated rule. The court has determined what information must be included in these forms. The information is not there. It's not possible, as a result of that, to determine the basis for the finding that there was any trespass or nuisance. It's not possible to determine the basis of the damages. It's not possible to determine the basis for the court dismissing.
What about just looking at the evidence? Can't we determine it just by looking at the evidence to see if, well, was there evidence supporting this?
Yes, but I understand that, my brother is arguing that the agreement, this is an argument that the court should be looking beyond what the parties submit if that is defective. The court decided that there needed to be a corrected verdict slip based on the elimination of certain claims. The court at that point should have also taken it upon itself to ensure that the form complied with Rule 20, which is the court's procedural rule. And in order to ensure equitable treatment of these claims, particularly when you have mirror claims for trespass and nuisance, yes, it is our position that this court can look to the evidence to determine, even though this is an abuse of discretion standard, and we understand that it's highly deferential, nonetheless, there has to be some basis for the decision. And that, a look at the corrected verdict form, which is attached to our brief and also in the addendum, shows that there isn't even a modicum of information as to how the court determined that there was a trespass and nuisance by the Tamuis. Ms. Battles had no expert testimony as to where the source of the water was that damaged her property. And indeed, Mr. Tam and Ms. Mui's expert, Ronald Taberry, 30 years of experience as an expert hydrologist and a drainage expert, understanding how these things work, said, there's an unnatural concentrated flow of water from Miss Battles' property to the Tamui property, and their attempts to try to divert the water, not to block it. He also testified there's no way for them to have blocked the water with what they did. They were trying to channel the water further down the fence so that it wouldn't end up continuing to damage their patio, their pavers. It was going to cost it cost them $86,000 to repair the damage to the patio and all of their plantings and everything that they had put in as a result of the water, concentrated flow of water, unnatural, which they also had an expert in Exhibit 17, which is cited in our brief, who said that the two sumps that are located at Ms. Battles' property, that there were two sumps, and that a sump pump is an unnatural diversion of water. Mr. Taberry, the expert, said there's a moderate slope, the water should sheet over the hill, and it should not be coming down with such force and concentration that it caused the damage that it did. And so what we have is expert testimony as to what likely the source is. There is no testimony from Ms. Battles as to the source of the damage to her property except her own. The Tamuis, the record shows, moved into their property in 2015. When they did, there were no water issues. At some point in 2018, the force of the water coming down through a fence that was already, the facts show, deteriorated and damaged, so much so that the town issued a citation against Ms. Battles for all of the panels falling down.
Yeah, that seemed like a curiosity. By what authority does a municipality tell a homeowner that they have to repair a fence? That just struck me as, was this Massachusetts? Is this the United States?
Yeah, there is a state statute about it, which
state statute, or is it a bylaw?
Sorry,
it
might be in the bylaw. We have the citation and the town officer's citation of that in the record, but I think because it's a hazard to have, there were significant panels. If you look at the photos in Exhibit 9 in the record, the panels are down the length of this fence, and Mr. Taberry testified that the fence was rotting from the top down. It hadn't been maintained. It's an old wooden fence. These are typical of conditions that you might see in New England, but she hadn't done anything about it. Consequently, the judge issued damages in the amount of something like $22,000, which was exactly the estimate provided by a landscaper that Ms. Battles had hired to address wetness that she claimed that she was having in her yard, but there was no causation for that wetness. And those two sumps and their diversion of the water from Ms. Battles' basement onto her own property could very well have been the source of that water. We don't know because there's no evidence to make that connection.
But
we don't have any evidence as to what that amount of damages is even for.
The judge was not bound to accept that, though. In other words, there was also testimony that these properties are at the foot of the Blue Hills Reservation, so there's a lot of water that just naturally comes down that hillside, and that may very well be where the water came from, and it had nothing to do with the plaintiff, pumping water out of her cellar or
well,
whatever.
that may be, but in the face of expert testimony on the one hand, and again, this is for coming down from the Blue Hills. It is not correct. I know there's a footnote in my brother's brief about suggesting that this property is the lowest lying property of all these neighbors. That's not correct. It's just, then there's no evidentiary basis for that. Yes, this property is downhill. Mr. Taberi, the 30-year veteran, testified that the undulating, moderate slope should have resulted in a sheet flow. And the photographs that show the damage along Ms. Battle's side of the fence are consistent with what you would have with a fence at the base of a slope with trees all around it and showing that there is erosion near the base of the fence. But there wasn't anything to show that the damages that have been awarded that appear to be for landscaping and not for the fence, that there is any basis for those being assessed against Mr. Tam and Ms. Mui. And all of this flows from that use of the Rule 20 verdict slip, which didn't set forth these claims. Now, Mr. Tam and Ms. Mui also had claims for trespass. There's evidence in the record that shows that Ms. Battle's fence trespasses on their property. We don't know why the court found trespass on the part of the Tam Muis. We don't know if it's because portions of Ms. Battle's fence were not directly on her boundary line, but within her property.
They were nailing boards to her fence.
That they nailed boards to a plank. They didn't nail boards to the fence, and that's consistent with Mr. Taberi's observations and testimony, and it's consistent with. Remember, these planks were about 6 to 8 inches at the bottom. There isn't any evidence to show, A, that they blocked the water at all. They couldn't have. The fence was so deteriorated at that point, all they were trying to do was divert it. But there's no evidence to show that this unnatural, forceful flow of water would have been of such a force and such a height that it would have backed up the slope and onto the playground area.
The videos were pretty good evidence, but correct me if I'm wrong, but I thought the boards were initially attached to the fence, and then when attached, I forget if it was nailed or there were sandbags or something, they were up against the fence. After the police came, they moved them, backed them off from the fence, and then they put stakes in the ground and attached them to the stakes that were in the ground. Is that correct?
There is disputed testimony that there were nails used anywhere on the fence. Mr. Tam and Ms. Mui expressly denied it as they testified and said that the nails were used in planks. But in any case, there is no evidence whatsoever that nailing boards into a rotting fence caused that fence to be damaged. The damage is long before any boards. But Mr. Taberi testifies, and in his letter, his report also says that there is no way that the water was sufficiently blocked or backed up. It would have had to have risen to such a level, such a high level beyond and above the 6-foot sort of plank that was at the bottom that we see from the photos, that there's no way that it stopped the water, that it would have to have been 8 to 10 inches of water that would have backed up into the area of the yard where the play set is, which is closer to the house, which we understand or believe is the basis for the judge's damages simply because she incorporated that number wholesale from a landscaper. But there's nothing in the landscape invoice to say this water's coming from your neighbor. There's nothing in the fence reports that were the invoices to say this water is coming from your neighbor. But we have also a judge dismissing counterclaims that are based on this same record. Counterclaims that show the forceful concentrated water, not a gentle sheet flow over it, but concentrated water that can only be from an unnatural
means. Yeah, but the judge could have, as I had said before, could have come to the conclusion that, well, the water was really coming from natural rain. It happened to be heavy rain over a couple days, heavy rain coming down the hill, and could have been exacerbated by the fact that the defendants, it looked like when they built their home, they carved out, it's almost like a basin, that they carved that, they changed the landscape, they changed the grade, they cut down a lot of trees. They could very well have contributed to that water no longer being absorbed in the land and, accumulating on their pavers and so forth.
That is a possibility, but there is no expert testimony to establish that. And Ms. Battles, with all due respect, is not an expert. She let her fence deteriorate to the point where it's unsightly and falling down pretty much the whole length of it. But because there isn't a complete Rule 20 verdict slip that puts out the elements so that we know. We don't know why the court decided what it, maybe that's the basis for it.
Counsel, I'm missing, I'm glad you went back to the verdict slip, because I'm missing what is improper about what happened here. I can find no case law that says that the parties cannot agree to dispense with a Superior Court rule. Constitutional claims can be waived based on counsel's agreement. So why can't a rule?
Because the rule provides the minimum that must be provided in the verdict slip, and the rule provides that the minimum that must be provided in the verdict slip are the elements of the claims being made. And without
That can't be waived under your theory.
not for this court to do a complete review based on simply the Rule 20 verdict slip. I think this court then is tasked with having to go back and examine the evidence to determine whether the court had any basis for its decision.
Okay.
Thank you.
Thank you.
I'll rest on my papers if there isn't anything.
Good morning. May it please the court, David Conti for the plaintiff appellee RITA Battles. I think at its base, this case is sort of the age-old adage of how does water flow, right? And I think there's no dispute in this case. There are a couple of undisputed facts in this case. One is that the TAM's property is substantially downhill from the Battles property. There's no dispute about that. Everybody has seen it. The surveyors have confirmed that. Secondly, the other undisputed fact is why the boards were placed where they were. And it's undisputed because the TAMs have admitted why they placed the boards where they were. And that was to unnaturally divert the flow of the water coming from the Battles property downhill onto theirs. Okay? So those are two undisputed facts. So we have a trial here, and the parties agree to a special verdict form. Okay? Now what the appellant would have the court believe is that any defect in the parties' agreed form would then give grounds to overturn the decision because it's not in compliance with the rule and the parties can't agree otherwise. That would essentially render every single jury verdict, every single jury instruction that the parties agree to null and void and subject to appellate review. There would be no stopping that. So it would be a perverse result, right? That a party could say, here's the form to use, jury, and call it a jury case. Here's the form to use, jury. And the jury fills that form out. And they don't get the result they want. And they come to you and they say, we need a new jury. We need to have, 6 or 12 or 14 more members of our public sit for another trial because the form I agreed to use is insufficient, and as a result, my clients didn't get the result they liked.
But the rule does say, when the parties agree to waive the detailed findings, the following rules shall apply, mandatory.
Correct, correct.
And at a minimum, the judge shall answer special questions on the elements of each claim at a level of detail comparable to a special jury verdict.
Correct.
Are you saying that this was at that level?
Oh, I would say that it is not. I would say there is no doubt that there are missing elements in the two questions that the TAMs asked the judge to find. Keep in mind, this is the questions they asked them to find, right? So if you look through that, right, and the court were to say, hey, you know what, yes, this is unwaivable, I think the result needs to be to send it back to the Superior Court judge and say, here, use a form that complies. And at the end of the day, I don't think the judge is going to find that the Miss Battles committed trespass and a nuisance. I think the court is going to find, consistent with the evidentiary record, that, in fact, the fence is wholly located on Miss Battles' property. Why? Because Miss Battles has a surveyor that says, in fact, that those were there. I think the court is going to say, well, why did they do what they did? Was the trespass intentional, and was it for an improper purpose? Of course it was, because that's what they said they were doing. They said, we didn't like the water flowing down the hill towards our property. So we're not experts, so we stuck some boards there and tried our best to do it in a way that we thought would divert the water. That's their testimony, right? And the damages are clearly supported by the evidence because we have a landscaper that says this is going to be the cost to replace the damaged grass.
Let me ask you about the damages. So there's two different estimates. One is February 6th, the other is February 25th. On the February 6th estimate, it's for $1,964 to replace 144 feet of fence.
Mm-hmm.
So that would be about $13 per linear foot. So weeks later, the estimate comes in for $28,800 to replace 322 feet of fence. That's over $89 a linear foot.
Hmm?
Why was there such a substantial increase?
Well, I don't
Go from
know
$13 to $89 a linear foot?
I
What's
don't
going
know
on?
why there was a substantial increase, but I'm not sure it's terribly relevant to the court's
Well,
analysis here because and those were not the estimates that were used. In fact, the trial court disregarded all costs for the replacement of the fence and only gave my client damages for the replacement of her yard, which was damaged as a result of the flooding. So it does appear, in fact, that the court disregarded my client's damages for the damage to the fence because the fence was in disrepair.
What do you mean, where does it say that replacement of yard?
There is on, it's a separate estimate. It's Record Appendix Volume 3, page 75. It's an estimate from Alex's Landscaping, Inc., and it addresses, and it's for the exact amount, $22,750 to reseed her yard due to the damage to the grass because of the water.
But, okay, so you're saying we know that based on the value?
We
In
know
other
that
words, the
because
judge-
it's to the dollar the amount of the exact amount of Alex's Landscaping, Inc.'s invoice, and the other two estimates appear to be completely disregarded. I mean, the only inference to draw from that is that the court accepted the damage to the yard, but didn't give my client damage to her fence because the fence had been in disrepair and the town had cited her for the disrepair. And there was no evidence in the record that the rotting of the fence had been caused necessarily by the water in the same way as the damage to the yard.
Okay, so you're saying that so that reference that the fence person who wrote up the estimate, his reference to the damage being caused by the water and so forth, needs replacing due to severe rot caused by extreme moisture, that played no role in any of this?
It appears not to have. I mean, it may have played a role in the court's finding that there was a trespass and a nuisance condition, but it was does not appear to be part of the damages that were awarded by the court to my client as a result of the trespass and the nuisance, because the damages that were awarded are to the dollar, the figure from the landscaping company, simply to reseed the yard. So it appears the court accepted the damage to the grass in the yard, but not the damage to the fence itself. So other than that, as to the adequacy of the evidence, my sister spends a lot of time on Mr. Tiberi and how he was an expert. And I've used Mr. Tiberi before. He is an expert witness. Problem with Mr. Tiberi's testimony in this instance is he wasn't hired until 2023. He can go on the property until 2024, and when he did, he never even went onto my client's property. In fact, his testimony is clear. He didn't even look at my client's property. How could he render any testimony that my client made an unnatural alteration to the flow of the water without having been there during a rain event, which he testified he never was there during a rain event? In fact, the boards were removed in 2023. So by the time he got to the property in 2024, the boards were gone. He never even visually observed it. His testimony is completely dependent upon a couple of photos, which we don't even know necessarily which photos and videos he was given, other than the fact that he says, well, it was the same ones we've seen. How is that testimony credible, number one? And number two, the court isn't bound to accept that testimony. In fact, Ms. Battles testified that she had lived at the property since 1999, that she never had any problems with the water until they put the boards up. We've got testimony from Joseph Prondak, a former Town of Milton building inspector, who testified that in fact he was on Ms. Battles' property and he observed no changes to her property at all. And if you look at the photos of the properties, it's clear Ms. Battles' backyard is a yard with a swing set and grass. There is no unnatural alteration. There's no impervious surfaces. There's nothing else by which Mr. Taberi could have based that testimony on. He based that testimony on viewing video and seeing water flow down a hill in a way that he didn't think it was there, but he wasn't there or present for any of those events. So I think the court was well within its discretion to disregard Mr. Taberi's testimony. There's no requirement that the causation element be established in a trespass case by expert testimony. The standard for trespass is simply that my client had a right of possession, that there was an intentional entry onto her land, and that damages were caused by that. And the record is replete with evidence that would support those findings. We've got a survey that says the fence is completely on her side. We've got photographs which show the survey stakes and show even the planks that were placed there to hold the boards in place inside the survey stakes, i.e. on my client's property. And we've got Mr. Tam's own testimony about what the actual purpose of placing the boards there were. The purpose was to divert the water. He was admittedly not an expert. He diverted the water, and he diverted it, at least apparently according to the trial court, by holding it back and causing flooding on my client's property. That's an unnatural alteration of the flow. And the case law is very clear that that's all that needs to be shown. For nuisance, substantial and unreasonable interference. In fact, there is flow of surface water standard says the defendant will incur liability when the harmful interference is unreasonable. It was well within the court's purview to state that affixing boards to the bottom of a fence and sandbags and everything else to hold water back from flowing down the hill because your property is downhill is an unreasonable interference with the natural flow of water. That's what this case is about. The Tams are unhappy because they bought a home, dug it down so that they could landscape it the way they want, and as a result, water flows down the hill onto their property. And they tried to stop that, and they were found liable for that to my client. The evidence is sufficient in the record, and I would respectfully suggest that at best, sending the case back with an instruction for the court to use a Rule 20 slip that is consistent but still makes the same findings, because it would be patently unfair in these circumstances to allow a party to submit a Rule 20 special verdict slip by agreement and then magically get a new trial because they didn't like the result and claim that there's a technical deficiency.
Can I go back to your, and I know it's not a suggestion, but in the alternative, send it back to answer. I'm looking at the rule, and there's a clause that seems to be being ignored. It says, at a level of detail comparable to a special verdict form pursuant to Mass Rule Civil Procedure 49A, unless the parties explicitly choose. So isn't that where the parties can agree that the judge doesn't have to basically follow the rule because they've explicitly chosen not to follow the rule?
I tend to agree, Your Honor, except for the second part of that clause, and I know there is a comma there.
And an or.
And an or. So, and I think I do tend to agree that there is an or there. I think that reading the clause together, it says or findings and interrogatories, and I can't remember the exact language of the rule, but there is a second part, I think, to that element of the rule, which makes it harder to just simply say, the rule says the parties can agree otherwise. I think that that should be the rule, is that if the parties agree to the special verdict form, they are bound by it and it is waived. I think that should be the rule. I think that should always be the rule. I think that's the rule if you use a special verdict form and submit it to the jury, because you're not going to be able to come back and ask the Commonwealth to produce more members of the public to sit through a trial because you are now unhappy with the result and want to claim a technical deficiency with the very form you submitted. It would be the same thing if I submitted jury instructions to the judge and the judge read my jury instructions and chose my jury instructions. And I lose. And after the fact, I say, well, you know what? You missed one. And the reason you missed one is because I missed one. But now that's a deficient verdict. I don't think you're going to be able to do that either. And I think this rule should be interpreted in the same way, that if the parties so choose and the judge accepts what they've chosen, you should be bound by that on appeal. That doesn't mean you can't still challenge the sufficiency of the evidence. That doesn't mean you can't still come in under Simmons and say, hey, the record is not sufficient to justify this. It just means you can't come before this court and say, the form I agreed to use was deficient, and challenge the actual form itself.
Thank you.
Thank you. If there's
Thank
no
you to
further
both
questions,
parties.
I'll rest on my brief.
The case is submitted. At this point, we're going to move on to the next case. That is 24P 747, TORRES, SCAMMON, HINCKS Day LLP versus Stephen F. Cass. I'll ask the appellant to please step forward.
Before I begin, I want to let you know my front tooth broke off this morning. So if I'm fiddling with it or if it falls out and I don't look too pretty, that's why. So I just wanted to make you aware of that. So hopefully I can manage without. May it please the court, my name is Stephen Cass and I'm representing myself in this matter. Exactly 10 years ago, I was fired as Wayland High School athletic director for doing right by kids. I read in the paper this past week there was a boy from Sharon that sustained brain damage because the school didn't protect their kids. And there was a football coach in Medfield who involved in some kind of financial fraud. I lost my career, my life, my home for dealing with those things and doing the right thing in this world. And I dealt with things much bigger than what happened in Sharon and Medfield. And I came to the courts to get my life back, and I've lost everything. I hired 2 lawyers to take my case from start to finish, get me the equitable remedies promised by the legislature, and I had 2 law firms that, when they realized that the case was perhaps not as financially rewarding for them, they either pressured me to get out of the case, or they made me pay more money. And at the end of the case, they both decided they wanted to share nearly 60% of my settlement, in contrast to what I had agreed to. So from a legal perspective here, I think some of the things you just heard, I had prepared for a jury trial as a pro se person, and I was told by the judge I was probably not going to get one, and at least that day or for a while. And she urged me, or she pressured me to do a finding of fact. And and a minute later she said, "What do you think? You going to do this?" I felt pressured, especially as someone pro se. And
I'm sorry, are you talking about when you talk about being pressured, are you talking about a judge or a lawyer?
The judge.
Okay.
I felt pressured that I was required to waive the finding of fact. And in the end, I don't believe that the information presented rose to the level of a jury verdict form. So I think this should at least be remanded to get a finding of fact from the judge. I wouldn't have waived that if she hadn't pressured me. One of the things in the special verdict form was quantum merit. And she had said right up front, if there's a contract, there's no quantum merit. but yet she determined there was a contract, but yet she still gave them the quantum error claim. I have no idea how she could have come to that conclusion. And so I do believe, at the very least, it should go back, and the judge should find facts. This case is basically about the responsibility of lawyers when there's a change in representation in a contingent fee case. The TORRES, SCAMMON, Hinson day, they want to look backwards from when the settlement happened. They want to look backwards at the things that occurred after the settlement. And as I've stated in my brief, the law, Rule 1.5, the case law, all refers to the time when you change lawyers and you sign that settlement agreement. And that's the only piece that needs to be focused on here.
And you say that the firm was supposed to, what do you say that they didn't do that was consistent with the rule?
Sure. So the first piece is the first law firm, which is TSHD. They were required within 20 days to provide some basic information about how much time they'd put into the case to me. That's a requirement. The Malonis case said, you don't have to itemize everything. Maybe in the end you won't win, so we're not going to make you itemize. But you are required. I think Rule 1.5 says you shall. It's a requirement to do that. And that's going to help everybody craft the next part of it. So once we know how much time they've put in, successor counsel can then put together a package that I can agree to or I can not agree to in terms of how the two firms are going to share the settlement in the end. They didn't do that, and as a result, some things got messed up.
So how did things get messed up because of their failure to make that disclosure to you within 20 days?
Successor counsel didn't know how much time they had put in. I didn't know how much time they'd put in, and I would have no idea what their claim is on. This case revolves around a termination clause that's in the contract. They will get the lesser of fair value of their legal services or a contingent percentage. And what should have happened, the successor counsel and prior counsel, they should have figured out a way to share the contingent percentage. As I stated in my brief, and there's case law on this, both law firms would never get a full contingent percentage because neither of them did the full case. So the contingent percentage, which prior counsel, TSHD, would be entitled to, that would be a portion. That wouldn't be the full 30%. They would be sharing it with successor counsel. And so if this information came out as...
But they weren't awarded a contingency fee, right? Weren't they just paid for the value of their services?
So, again, the key point is in October, when I signed the contract, what did I believe my financial responsibilities were? Not in the end. We had a settlement for $800,000. It was a settlement. That's it. It was a settlement, and then it goes back to the contracts as to how the money is going to be parsed. That's why we have a settlement agreement. Is when you have a settlement, we look back at the settlement agreement. And so, in this case, successor counsel in the ABA, the Malonis case, the Bar Council, they have all stated it is the responsibility of successor counsel. It's really the responsibility of both lawyers to make sure the client has an accurate understanding of what their financial responsibilities will be at the end.
Can I ask you about
Sure.
that? At the time the settlement agreement was entered, APS was keeping you informed of the negotiations, correct?
When the settlement...
The negotiations were going on regarding the settlement agreement.
At the end?
Yes. Yes.
No.
They were not?
It was a month where they were discussing with the other law firm.
Okay. And you were not kept informed about those negotiations and what the ultimate agreement was going to be?
Sure, I knew the ultimate agreement. They said we have an $800,000 settlement.
Okay. And was there any discussion at that time that TSHD is going to get this amount and APS, we're going to get this amount and you're going to get this amount?
Sure.
So three pots, so to speak.
They told me what they were entitled to, which...
Well, did you agree to it?
No, absolutely not. I had to get another lawyer to deal with my lawyers, because this was the time
Where is that in the record that you disagreed with it during the settlement negotiations, or ultimately when the settlement was entered, that you objected to the three pots that I just went through?
Because I had to get another lawyer to basically...
But that was after you signed the agreement, wasn't it?
No. I had a contract with APS, and when I signed my contract, it said I would owe them 25% of contingency, and I would owe prior counsel a lien of $45,000 or less. So when I signed with successor counsel APS, my belief, and I was a former math teacher, I would owe 25% plus another $45,000. So if I had, I went through all the permutations. If I settled for $500,000, I'd owe them 125 APS. I'd owe the lien of 45. That would be a 34% contingency.
So that was your agreement with the second firm?
Yes, but case law, the ABA is very clear. If successor counsel doesn't make things clear as to what your full responsibility is, they are on the hook for that. And what I was saying, I agreed to $45,000. I've always agreed to that. In fact, I offered them more than that after the case because Mr. Hinks had helped me on some other things. But I shouldn't have to pay above that. The law is very, very clear. The ABA and the SJC, they both confirmed this. Successor counsel is responsible to make sure things are crystal clear. And anything above the $45,000, I'm not responsible for because I didn't agree to that. I agreed to the 25% with Adler, and I agreed to a $45,000 lien with TORRES, SCAMMON, Hinson Day. And that's all I agreed to. It was right there in the contract, and the law is crystal clear. Successor counsel is responsible. If they don't do that, all they had to do was make a phone call or send an email. And then we would have gone back to renegotiate. But they told me a $45,000 lien. I conveyed that to successor counsel. They put that right in my contract. Said, this is what you owe. And so I went into the rest of the case, and again, I'm the only one that wants to go to trial. I keep putting up more money. I went into that case thinking I have a $45,000 lien and a 25% contingency, and that is a reasonable amount of money. That is going to put me somewhere in the 35% range at the end of the case. The fact that the lawyers in the end decided they were going to tell me at the end how to carve up the settlement, that's what the contract was for. The contract, that's why we sign contracts. So you look back at the contract. I didn't have any leverage at this point. There's nothing. I hired another lawyer. He ended up stealing a big chunk of my settlement. That's a whole different story. He was disbarred for that. So we had a settlement, and you look back at the contracts. It was just that simple. There was nothing I could do. Adler, Pollack, and Sheehan was not advocating for me in post-trial negotiations. They were advocating for themselves. And all I could do was say, I have contracts that say Adler, Pollack, and Sheehan is only entitled to the $150,000 I get. I had to fight Adler on this, and I won, because I had a contract that said they got $150,000 and that's it. They wanted 130 more. At least we went to mediation. So the contract is very clear. Case law and the ABA and the SJC are very clear. Successor counsel is responsible for anything over the $45,000.
Where's the $45,000 referenced in the record?
Oh, that's RA2 207 262. It's 17 in the brief, and that's what I agreed to. The other piece of this is, what is the real reason they withdrew? And they said they went to Judge Bowl, and I was having thoughts of suicide, and they're correct on that. And they withdrew from the case. they said that, that they were afraid the stress of the trial would be too much for me, and Attorney SCAMMON said, we don't want to put him through a trial. We want him to get on with his life. How that contradicts with their decision not to go to arbitration in this case and put me through a 5-year lawsuit in this case. So there was a Falco case from California. So first, there's the Kiley case here. It says, if your main motivation is financial, you're not entitled to recovery in the end. The Falco case, that's been cited hundreds of times around the country, and I suggest the court adopt it. They give a 5-point test. The first one is, did you get mandatory, were you allowed to withdraw, which they did. The second one is, what was the true motivation for withdrawal? And if it wasn't the primary and overwhelming reason, if adherence to ethical standards was not the primary reason, then you're not entitled to any recovery. And I provided in my brief all of these examples. Okay, they pressured me to get out of the case. They pressured me and pressured me. And there was a 0% chance I needed to get reinstatement to my job and my retirement. I needed to win a whistleblower case. And when I wouldn't take the settlement, they withdrew. It was for financial reasons.
But didn't you agree at the time that the withdrawal was appropriate under the circumstances?
I just gave a non-committal answer. I understand what they're saying. I didn't agree with that, and I wasn't going to lie in court. I just said, if they want out, they can be out. It's for this court to weigh the evidence.
Well, actually, it was for the trial court,
and
right? And we're bound.
Sure, but the overwhelming weight of the evidence is that they withdrew from this case for financial reasons.
So can you tell me something about the financial reasons? What was the financial state at the time that would have caused them to withdraw from the case?
It was taking too much of their time. It was becoming a burden.
Is there something in the record that we can look at to see that there's some evidence that they really wanted to get rid of this case? It was taking up too much lawyer time at their new firm?
There's not, but I think if you weigh all the evidence, the fact that we're here right now, that on the one hand, they were saying it's so important, we're so worried about Mr. Cass, but then we're willing to drag him through a 5-year trial. And, my life has been destroyed by this whole thing. I guess the last thing I just want to say is, I think I should only be held to that $45,000. Successor counsel, the law is very clear on that, and successor counsel should be responsible for anything else.
Thank you. Thank you.
Members of the panel, may it please the court. I'm Benjamin Hinckes. I represent the appellee Tory, SCAMMON, Hinson Day in this matter, which I'll refer to as TSH&D or TSHD. Thank you for hearing the parties today. I know you've read the parties' submissions and are familiar with the underlying record. I'd like to cover just 4 brief points of emphasis in my presentation this morning, but before I get there, I guess I'll add a couple. Mr. Cass made reference in his argument to feeling pressured, I think both to waive a jury in this case, but also to waive detailed findings of fact. That was not raised on appeal. There is a footnote, I believe, in Mr. Cass's brief saying if for some reason the court remands back, he would ask that the court instruct the trial judge to make detailed findings of fact, but there was not an appellate issue raised on his waiver, nor do I think one would have been successful. There's an extensive colloquy at the beginning in Record Appendix Volume 2 between the judge and the parties, including Mr. Cass, both on the waiver of the jury. There wasn't a jury available. She explained, my recollection, she explained that it could take some time. It might require a further continuance of the case. She gave Mr. Cass time in recess to consider it. When she came back, also gave him time to consider waiving findings of fact and conclusions of law. And when she came back, she asked Mr. Cass if he agreed to waive. And he did, as did Tory, Scammon, Hinks, and Day for its own reasons. But, Your Honor, the other thing I want to mention is Mr. Cass did have counsel in this appeal, apparently. He made a reference to it in a request for an extension, said he had counsel he was consulting with. So he has pro se, but he's also been conferring with counsel and did not raise this issue on appeal. The only other point is just on the alleged $45,000 lien. Mr. Cass raised that in the case below, in the trial record below. There is a trial exhibit, Exhibit 35, in which it's an affidavit of Mr. Cass himself. When it suited him to argue that there was no lien, which he has earlier in this case, he wrote an affidavit saying that we had a discussion about a $45,000 lien, and the appellee does not dispute that. There was a reference to it, that it was being considered, but as Mr. Cass writes in his affidavit, it was not codified or written down. He also admitted in interrogatories in this case that the fee agreement with Tory, Scammon, Hinks, and Day was never amended. Again, I think the $45,000 lien is something that was raised, but the trial court certainly had the discretion to not credit Mr. Cass's position on that. So, to my 4 points of emphasis, the first is the standard of review. Under the present circumstances, the standard of review, I would submit, is highly deferential. Clearly erroneous standard as to the trial court's factual findings, but there's further guidance as well, whereas here, the parties have both waived detailed written findings of fact pursuant to Mass Superior Court Rule 20, subsection 8. The parties additionally waive all arguments in the trial court or on appeal that require or depend upon the existence of detailed written findings of fact. Moreover, as guided by this court's decision in KK Development versus Andrews from 2023, the standard of review after such mutual waiver can be summarized as follows, and I'm quoting, "Whether anywhere in the evidence from whatever source derived, any combination of circumstances could be found from which a reasonable inference could be drawn in favor of the prevailing party." And part of that is quoting this court's decision in Matsis versus Ming Supermarkets from 2019. The second point relates to the diving into the underlying factual records supporting the trial judge's special verdict ruling in TSHD's favor. The underlying record is rife, I would submit, with evidence submitted to Judge Squires-Lee over the course of the 3-day trial that fully support her special verdict findings that, one, Mr. Cass breached his May 2016 fee agreement with Tory, Scammon, Hinks, and Day. In the alternative, following traditional principles of quantum merit, that Mr. Cass breached an implied contract with TSHD, entitling the firm to be paid for the reasonable value of its services rendered. And 3, that the single damages award due and owing to TSH&D arising from either or both breaches was the amount of $190,634 plus prejudgment interest. While we go into greater detail as to these underlying facts in our brief, in summary, we submit that on the underlying trial record, Judge Squires-Lee could reasonably have made, and very likely did make, at least the following 3 key factual determinations in issuing her special verdict rulings, all of which may be derived from the termination provision in the fee contract itself, and all of which were completely supported by evidence in the trial record below. First, there's myriad evidence that Mr. Cass benefited from TSHD's services rendered over the 2-year representation. The evidence can be found not only in exhibits, documents in the record, but also from the testimony of TSHD's attorneys, Scammon and Hinks, from Mr. Cass's own testimony, and from the testimony of successor counsel Todd White of Adler, Pollock, and Sheehan, APS, who testified that the TSHD work product that he inherited was very good, and that the fact that discovery was completed when APS took on the case was part of the reason that they decided to go forward. Add to that additional evidence, members of the panel, in the record, that immediately before Tory, SCAMMON, Hinson Day withdrew from the case, the settlement value of the case, as recommended by Federal Magistrate Judge Collings, was $300,000, and that this $300,000 value was 20% higher than the $250,000 award Mr. Cass ultimately received against the town of Wayland at trial. The second fact that Judge Squires-Lee likely found, or certainly could have found from the record reasonably, is that the court could reasonably have found on the record that the timing and circumstances of the TSHD termination of representation justified the award of the fair value fee to the firm. For example, the trial judge not only had the benefit of Magistrate Judge Bowles' hearing transcript and ruling in September 2018 that TSHD's withdrawal from the representation was, and I'm quoting, required pursuant to Rules 1.7A2 and 1.16A1 of the Massachusetts Rules of Professional Conduct. But Judge Squires-Lee was also able to revisit that determination essentially de novo, and in receipt of an extensive body of evidence concerning the conflict of interest that the firm faced after Mr. Cass's revelation of imminent intent to commit self-harm. Mr. Cass did not dispute this factual basis for or object to the withdrawal motion before Judge Bowl. In fact, the evidence shows that he even complimented the TSHD attorney Hinks, myself, a few days after the withdrawal hearing in an email saying, "Thanks for doing a great job Thursday. Hopefully it'll go a long way to helping find the best lawyer possible." Third and finally, the trial court's finding that TSHD was entitled to the entire $190,634, which was then being held in the Superior Court's escrow and had been negotiated by TSHD with the town of Wayland at the direction of U.S. District Court Judge Patty Saris, was and is also abundantly supported in the underlying record. We submit that there's multiple ways that Judge Squires-Lee could come to the conclusion of that of that award in this case. One was the extensive documentary and testimonial evidence that Mr. Cass was aware of and blessed the negotiation and allocation of that exact amount to be paid by the town of Wayland as part of the $800,000 settlement. And Your Honor, there is evidence, there's extensive testimony from Attorney White as to the fact that he kept Mr. Cass informed of the negotiations as they were going along. He testified to a meeting that he believed was in late October of 2019, I guess it was at the time, in which he laid out for Mr. Cass who was going to be paid what in the agreement. And then he even testified that he was surprised that there was even a dispute because he didn't recall Mr. Cass having an objection. Certainly Judge Squires-Lee was entitled to credit that testimony over Mr. Cass's.
Can I just ask you a question?
Yeah, sure.
So I just want to understand this. So in the end, $800,000 is the total amount.
Yes.
Your firm got 190 out of that, right?
Yes.
What did the other firm get?
APS was paid $150,000. Now, that's an excellent question, Your Honor. That was, and Mr. Cass has been inconsistent in his presentation of those fee agreements with Adler Pollack. The first fee agreement, it's in the record before the court, was for $100,000 to be billed at a certain rate as a retainer, and then 25% of any amounts recovered over $400,000. Okay, so it's not 25% of a recovery, it's over $400,000. That contingency fee agreement, if you will, a year later, or less than a year later, months later, was wiped off the books essentially because there was a revised agreement in which Mr. Cass agreed to pay an additional $50,000, again, in retainer to be billed by APS, and the contingency was removed. So the position that, oh, there were two contingencies that Mr. Cass was exposed to is simply not accurate. There were two agreements that had contingency provisions. The TSHD provision as the law says, was essentially wiped out as a contingency fee agreement when the termination, the withdrawal happened. The Adler, Pollack, and Sheehan one was eliminated by the parties themselves. So by the time the case was resolved after trial and negotiation of the fees, there was no contingency fee agreement to which Mr. Cass was exposed or was triggered. And in fact, the town of Wayland paid paid certainly the amounts that had been negotiated by both firms on Mr. Cass's behalf. He netted in the recovery $610,000 of the $800,000 settlement, leaving only the amount in dispute in this case for Mr. Cass.
Can I ask you
Yes,
about that?
please.
That's where I got confused.
Sure.
I'm a numbers guy, but I'm not good at math. He got $250,000 as a verdict.
Correct.
He gets 12% prejudgment interest on that verdict.
Yes.
Whatever that amount is, 12% plus the $250,000. That's all he was entitled to. So why is he involved in this? I'm going to say standing, but it's not really standing. Why is he involved? The remainder of that $800,000, which is $800,000 minus the $250,000, which I just said, plus the 12% prejudgment interest, the balance of that was negotiated is just attorney's fees. So why is he involved in this? In a legal sense, I'll say.
Well,
it had nothing to do with going in his pocket.
Yeah, that's an excellent question. I don't have all the answer to that because part of it relates to the agreements that were between Mr. Cass and Adler, Pollack, and Sheehan, okay? So Mr. Cass was immediately paid $476,000 at the time of the settlement and the town of Wayland making the payment. That reflected the $250,000 judgment, the prejudgment interest, and the $150,000 that he'd already paid Adler, Pollack, and Sheehan, which was part of the APS negotiation and was returned to him. Okay? Some point thereafter, and it's not clear in the record, it wasn't germane to our case, but Mr. Cass admitted that he received an additional amount of money from the settlement escrow, leading his total recovery to $610,000. And so there's something there between Adler, Pollack, and Sheehan. As it goes between Mr. Cass and TSH&D, I would agree with your question, with the premise of your question. The termination provision in the agreement, which is set forth as an identical verbatim form agreement in Rule 1.5, and we're happy to say we had it in the agreement, but it lays out the post-termination calculus.
Let me ask you this.
Yes.
And again, I don't know how the numbers would ultimately flush out, so to speak. Let's say we ruled against some of the attorneys. Shouldn't that money go back to Wayland?
That's an excellent question.
Because it's not his money. Wayland said, I'm giving $250,000 the verdict slip plus 12%. The balance of the money of that $800,000 is going to the attorneys. How it's broken up, whatever. But it doesn't go in his pocket, does it?
It's an excellent question, and I agree with that. However, I guess I would hesitate to say that it should go back to the town of Wayland, since we negotiated with the town of Wayland at the direction of Judge Saris to pay our fee. So here we are now 6 years later, and I would simply submit to the court, I'll rest on my papers from this point on, but we request that this panel affirm Judge Squires-Lee's ruling on her special verdict form, if there are any other questions?
Yeah, I do have
Please, yeah.
on the, just getting back to Mr. Cass's point about the firm not laying out its bills 20 days after termination. Okay, so you agree that you didn't do that. Do you agree that you were required to do that?
I do not, respectfully. I agree that we did not do that. Our view is that Rule 1.5 F1 excuses when you've got a model form agreement consistent with the agreement in Rule 1.5, as we do. Rule 1.5, I've got the language here, says that the following forms of contingent fee agreement may be used to satisfy the requirements of paragraph 1.5C, and it is in 1.5C where the 20-day rule applies. But even if, Your Honor, this court would find that 1.5F does not excuse an attorney's requirement in 1.5C to make that disclosure, the remedy that Mr. Cass is seeking is entirely draconian. It's not consistent with anything in Rule 1.5, and it's certainly not consistent with any of the law that's cited, including the case Malonis versus Harrington that Mr. Cass writes about throughout his brief. In that case, the attorney, the terminated attorney, who did not provide the detailed accounting within 20 days, got his fee. In fact, he was requested 4 times to provide that accounting and did not do so, but he was still given his fee, and essentially saying we're going to avoid a windfall here for a technical violation. There's also this court's decision, and my final point on this, thank you for hearing me, in the Sunrise development case, which is cited in our papers, this court just last year made a similar determination saying we're going to avoid a windfall, notwithstanding technical violations of Rule 1.5C. So,
Thank you.
thank you very much.
Thank you to the parties, and Mr. Cass, good luck with the tooth situation. We'll now call the final, I believe the final case of the day. That is 24P814, Robert Rodriguez versus John K. Ferrell, Jr.
Good morning. May it please the court, my name is Jonathan Silverstein. I'm representing the plaintiff appellant, Robert Rodriguez, with respect to the appeal of the Superior Court's award of summary judgment in favor of the defendants, Planning Board and Board of Health of the town of Fairhaven. The Superior Court rested entirely on 2 basic bases in granting summary judgment. The first was that the Planning Board's denial of my client's application for subdivision approval was necessitated by the Board of Health agent's letter recommending disapproval. And secondly, the Superior Court determined that notwithstanding expert affidavits submitted by my client contesting each and every one of the reasons stated by the Planning Board for denial, the Superior Court determined that that did not create a triable question of material fact because the plaintiff was resting entirely on information submitted subsequent to the Planning Board's decision to deny the original subdivision. So I'll address first the question of the Board of Health agent's letter recommending disapproval. And I think it's important to briefly review the facts and the timeline in this case because it's pertinent to both of the bases stated by the Superior Court for denial. So my client submitted his application for definitive subdivision approval on May 23rd, 2019. 1 week thereafter, the town planner sent copies of the plan. 10 copies of the plan, full size, were submitted with the application. And several of those copies were sent to various town departments, including the Board of Health. Now, I would draw the court's attention to volume 3, page 148 of the appendix, which is the Planning Board's own published form checklist, which states, Planning Board will submit plans to Public Works, Fire, Police, Board of Health, Board of Assessors, Conservation Commission, and Building department. So consistent with this past practice and with the published form of the planning board itself, my client submitted multiple copies of the application, and in fact, it's undisputed that the town planner forwarded copies, as indicated on the planning board's published form, to various departments, including the Board of Health. About a month later, the Board of Health informed the planning board that it had no comments. Explicitly informed the planning board it had no comments. A month after that, on August 19th, the Board of Health met and reaffirmed its determination that it had no comments because the property's on public sewer. And usually what the Board of Health is looking at is Title V issues regarding on-site septic systems. After a back and forth, as is typical in subdivision applications, between the applicant's engineer and the planning board's peer reviewer, the peer reviewer issued a final set of comments which was sent to the applicant's engineer on January 2nd, 2020. 12 days later, on January 14th, the planning board, the applicant's engineer submitted a response to each and every one of those comments. That same night, the planning board was informed, oh, and I should back up a moment. In December, 6 months after the application was submitted, for the first time, someone on the planning board said, oh, well, the applicant was required to submit the plans to the Board of Health, not the planner. So the applicant submitted to the Board of Health, even though the Board of Health had repeatedly reviewed the plans and said it had no comments.
Was that statement accurate? Is that the rules are that it be submitted that way?
The subdivision rules and regulations do state that the applicant should submit the plans to the Board of Health. The form, the planning board's published form, says that the planning board will do so. The statute just says that a copy of the plans have to be submitted to the Board of Health. Chapter 41, Section 81O. So, and in any event, it's undisputed that the Board of Health had them. But, okay, in December, 6 months after the application was filed, applicant was told, you need to do it. The applicant did it. And then on January 14th, at a continued session of the public hearing, the applicant said, as requested, we've submitted the plans to the Board of Health. We're scheduled to meet with them next week. And the Board of Health was also informed that the applicant's engineer had submitted detailed responses to all the comments, the final comments of the planning board's peer reviewer. Nevertheless, the planning board that night, two members of whom had already prepared statements of denial, voted to close the public hearing instead of waiting to see what the Board of Health was going to determine, and instead of reviewing the submission that the applicant's engineer had responded to that day, but only in response to comments that it had received less than 2 weeks prior, instead of waiting to review that information, which would have made perfect sense, the planning board votes to deny. Now,
can I break this down a little bit? So if we use that December 2019 date, the disapproval and denial would be timely, wouldn't it?
No, Your Honor.
Why not?
Because, first of all, what the statute says is not that if you don't have an approval from the planning board, from the Board of Health, the planning board denies. It says the planning board has to follow the recommendations of the Board of Health. There were, as of the date that the planning board voted to close the hearing and deny, all the planning board had in front of it was information that the applicant was scheduled the following week to meet with the Board of Health.
Just because the Board of Health approves a plan, that doesn't mean automatically that the planning board has to approve it, right?
Absolutely not, but I think we're breaking down two separate issues. One is the statutes, the Superior Court determined that because the Board of Health agent issued this denial recommendation, the planning board was required to deny. So that's issue number one. Now, there are a bunch of problems with that. Number one, that Board of Health agent letter came weeks after the planning board voted to deny. So the planning board clearly did not and could not have relied on that. All the planning board had at that point was repeated determinations from the Board of Health itself saying, we have no comments. And number two, there was nothing in front of the planning board at that time, and it was clearly arbitrary and capricious at best for the planning board to deny based upon the lack of a response from the Board of Health when the Board of Health had repeatedly responded after actual notice. And I would cite to Hickey versus Planning Board of Dennis for an analogous situation where the court said it's what is actually what the town clerk in that instance actually knew, not how it got that knowledge. And here there's no dispute that the Board of Health 7 months prior to the planning board vote knew of the plans, had reviewed the plans, and had repeatedly said, we have no issue.
Now, as you've described it, the closing of that public hearing seems to have been precipitous, unexpected. Did the applicant oppose the closing of the public hearing to say, oh, wait a minute, we've got something pending before the Board of Health?
Yes,
Can you keep it open? And that was just overruled?
The applicant's engineer was at that hearing and said, we've responded to all the comments we received just 12 days ago from the planning board's peer reviewer, and we're scheduled to meet next week with the Board of Health. And nevertheless, the planning board decided, preordained, since they were showing up with statements stating their reasons for denial, decided to close the public hearing instead of waiting for the Board of Health meeting, instead of taking the opportunity to review the applicant's submission, and decided to close the hearing and deny. So,
and in the, just to go back for a minute,
of course.
Clearly you, the applicant must have had to have agreed to waive that 20-day deadline at different points, right? Like from at the beginning.
The 135-day deadline?
Okay, yeah, right, the bigger deadline, that was waived at like, with an eye towards like something, like both parties in agreement that more information is needed or something to that effect? Was there anything like that done?
It's not in the record, Your Honor, but we're not asserting a constructive approval with respect to the original.
What I was driving at is I'm just trying to see if both the applicant and the town were on the same page in terms of, we're both in agreement that we're waiving deadlines here because both parties would like more information to be presented. And I'm just trying to see if the town didn't honor its part of that agreement by kind of short-circuiting this public hearing. As you've described it, it sounds like it was cut off kind of abruptly.
It was cut off abruptly. I came into the case to handle this appeal. I wasn't the applicant's counsel before the board or before the Superior Court, but I can tell you as, a land use lawyer, municipal lawyer for 30 years, this is just how it goes. There are peer review comments, there are responses, there are more peer review comments, there are hearings. It just sort of goes on. I do know that early on there had been continuance requests from my client in order to address some of the issues that had been brought up by departments, and that the first substantive hearing took place in September. So my assumption would be that there were, usually the planning board will, when an applicant requests a continuance, the planning board will ask for them to sign a form agreeing to a consistent extension of the required deadlines. But in any event, certainly at a minimum, an applicant who receives peer review comments and responds 12 days later has a reasonable expectation that the planning board is going to review that information before it votes to close the public hearing and deny. My time is running low. I think it's clear that the Board of Health letter which is inconsistent and was later rescinded by the Board of Health itself at the same meeting when it voted to terminate the employment of the health agent who issued it without any authorization, that is not a valid basis to deny. With respect to all the other reasons listed in the planning board decision and cited by the Superior Court, the Superior Court, I don't know how to put it more plainly, it was just wrong. It made a really surprising mistake because the Superior Court said, well, the applicant can't rely on information it submitted during remand 2 years later to oppose summary judgment on the original decision. But the problem is that just never happened. The applicant submitted 2 expert affidavits that cited exclusively to submissions that were made prior to the planning board original vote on January 14th, 2020, including the January 14 submission, January 10 submissions, and numerous submissions prior. If you look through the expert affidavits, they don't cite anything about remand. And they address one by one all of the reasons for disapproval cited in the Superior Court decision and the planning board decision. That's a clear contested issue of material fact. It's a matter on summary judgment. You can't just decide to ignore information that was submitted by the plaintiff's experts. And the Superior Court just got it wrong. As a matter of fact, the plaintiff did not rely on anything submitted subsequent to the original planning board vote, even if it had. This isn't a record review case. There are references to the record in my brother's brief, in the Superior Court decision. This is not a certiorari case. Chapter 41, Section 81BB says it's a de novo trial. The planning board's limited to the reasons for denial, and the applicant never referred to or relied upon any plans created after the fact, but you're allowed to submit new evidence. Even if we had submitted new evidence, we're allowed to in a de novo case. And the Superior Court just got it wrong in saying that we were not allowed to. I know my time is up. If I could have 10 seconds just to respond to an issue raised in my brother's brief on an issue of zoning. My brother relies on an issue not really addressed, not addressed at all in the Superior Court decision, saying that the town has a zoning bylaw that requires setbacks from windmills. But if you look at the clear language of the bylaw, which is attached in the addendum to my brother's brief, that is a setback imposed on the applicants for the windmills. It cannot, as a matter of law, without constituting a taking, say that abutting landowners are thereafter prohibited from developing their land. And in any case, the same bylaw specifically says it can be waived by the planning board. So I'll rest with that unless the court has any other questions.
Well, thank you.
Thank you so much for your time.
Good morning. May it please the court, I'm Michael Terry, represent the town of Fairhaven. So, as noted by the Superior Court in its decision, in order to have prevailed in this appeal of the Fairhaven Planning Board denial, it was Mr. Roderick's burden to produce evidence establishing that, 1, his plans fully complied with all applicable bylaws and regulations without waiver, and 2, that his plans had received approval from the Board of Health. So it's a two-pronged approval process. My brother keeps referring to the planning board's decision as being based on the denial from the Board of Health, but I don't think that's correct. If you read the planning board decision, they reference, they kind of obliquely refer to the filing with the Board of Health, but they don't base it necessarily on that. They do base it on concerns around health and safety of the residents and the surrounding neighborhoods, but that's not the basis really of their denial. Denial was based on all the myriad of ways.
Let me ask you this, because I agree. I mean, it's a very comprehensive opinion, and it's clear that there was a lot of thought put into it. the denial, the planning board denial. But I am concerned about this, that, you know, the concept of a public hearing, it has to be a genuine public hearing. It can't just be that, yeah, well, we'll give them a hearing, but we don't have to listen to them, sort of thing. And it seems, as your brother has, you know, represented it, it seems that this public hearing came to a close very abruptly, and it makes you wonder if there was much consideration given to the materials that had been submitted in December, just weeks before, but also there was the hearing pending, was already scheduled with the Board of Health, and yet it just surprises me that if I were on that board, I'd say, well, what's the rush? We have an agreement from everybody. Let's just get all the facts, and then we can make our decision. But why pull the trigger abruptly?
So first of all, the planning board couldn't approve a plan if it wasn't approved by the Board of Health. In this case, they were pretty clear they were going to deny this plan. So it frankly didn't matter to them.
Well, wait a minute, but there was still a hearing yet to be held by the Board of Health. So are you saying that was just sort of a perfunctory hearing, that their minds had already been made up?
Not perfunctory, but it really didn't necessarily impact their decision. And there was a misstatement, which was that somehow the applicant objected to the close of the hearing, which is not true. If you look at the minutes of the final meeting, Volume 3, page 36 of the record, they ask about, you know, they say, well, first of all, we just got these new comments today. This has been going on for 6 to 8 months. We have another letter from your guy, but we only received it today, so we haven't had time to review this. And their own subdivision rules and regulations provide that they can refuse to accept material that's not provided at least 14 days before the hearing. That's in the regs. So they said, we're ready to vote. Do you have any objection to us closing the hearing? He says no. So if he has some argument about that, I think he waived it on that issue. And I think I just want to bring your attention to kind of the big picture of what's going on here with this project. First of all, this is a very marginal piece of property at best. On one side, you have it, to the west, you have an existing neighborhood. Then you have this property, which is steeply sloped. It is 60% either wetlands or within the wetlands buffer. It abuts a wastewater treatment plant. And then, as my brother stated, there's two 394-foot wind turbines. So on the other side from the neighborhood. So from the neighborhood's perspective, you can imagine this was very just upsetting. For them, this is a buffer between them and the wastewater treatment plant and also the turbines. And so, so really that was kind of the genesis of all these concerns. If this thing is going to get constructed, essentially it has to be clear cut, all the vegetation removed. An unknown amount of fill has to be brought in, but it's a huge amount of fill. And then, so, but again, circling back to the reason for denial, it's based on all the the number of ways it doesn't comply with rules and regulations, and the case law is very, very clear. In order for them to be compelled to approve this, it was the applicant's burden to show that they did comply with any and all rules that apply, and that there was no waivers requested. Now, when I received the summary judgment motion from the plaintiff's counsel, he didn't even have an affidavit attached to it. He didn't even attach a copy of the subdivision plan. So I was presented with that. So I responded with our affidavit with the town's peer review consultant, providing a myriad list of all the ways it didn't comply, the basis for the denial, et cetera. He then responded with an affidavit, well, actually two affidavits, but one affidavit from his expert, his consultant. But within that affidavit, he didn't say anywhere that this plan fully complies with the rules and regulations. And in fact, that's where that issue comes up with, he refers to the later revised plan. Well, that was a plan that was not in the record. As discussed, the planning board had no obligation to accept that final revised record. And it doesn't even matter because they have consistently argued from day one that their initial plan was fully compliant. Not true, but that's what they keep saying. So he didn't say everything has been resolved. He made a lot of reference. He says, I disagree. If you compare the two affidavits, you'll see the appellant's affidavit is saying multiple times, I disagree, but doesn't say that it does comply. He refers to the plan that's not in the record. If you look at the vote of the planning board, it defines what plan they're ruling on. That was not the plan. He also refers to a subsequent superseding order of conditions that.
Can I ask you about the response of I do not agree?
Yeah.
Does that create a question of fact?
I don't think so. I mean, the burden is on him to show that, all right, here's my plan. Run it through your analysis. This complies with every possible rule and regulation that applies here. I mean, that's his burden. He didn't meet it. You can't, at the summary judgment stage, say simply, I disagree. That's not a question of fact. So, and if you take his affidavit and you remove any reference to the plan that was not before before the planning board, and then also, I was about to say, the superseding order of conditions, which he likes to rely on for stormwater issues, that wasn't issued until a year and a half later, and it would only apply to jurisdictional areas. We're not completely jurisdictional, so that's a red herring as well. So, the town's view is based on the record that we have established that the plan before the board did not comply with the rules and regulations.
What about the second prong, so to speak, the Board of Health?
Right.
At the time the planning board denied the plan, you didn't have the Board of Health denial yet.
True.
So how can the judge rely on that as a basis in supporting the planning board, partly, I'm not saying wholeheartedly, but at least partly on the Board of Health issue?
Yeah. Well, I think she's referring back to, their burden, which is you have to show that you had a fully compliant plan and you have to show that you had the approval of the Board of Health. And I agree with you that they're not necessarily completely linked. It's not the planning board saying, well, we love this subdivision, but we're going to deny it because they didn't get the approval of the Board of Health. That's not the case. They had their own reasons for denying it. The Board of Health issue is, the regulations say you're supposed to file a print copy with the Board of Health, and then if they don't respond under the statute within 45 days, that could be constructive approval. So that's what she was looking at. So they never did file with the Board of Health until that date in December. So they couldn't rely on that as a basis for an approval. So they didn't have a constructive approval.
Well, I think you're playing it both ways, which is kind of interesting. So they couldn't have applied for the plan on, I think it was January 14th was ultimately the vote.
Yeah.
They couldn't have applied because they didn't have the Board of Health approval, which they submitted on December 19th, but the judge can rely on that. Doesn't that seem a little...
I'm sorry, what was the first part of the...
So on January 14th, when the board makes the vote,
yeah,
they don't have the Board of Health approval or denial. It's still pending.
True.
So if the planning board makes a decision without the Board of Health issue, how can the judge rely on that? I guess that's what I might be with you on part one where, there's certain parts of the plan weren't there. But it seems like relying on the Board of Health approval or disapproval, kind of a red herring because the planning board couldn't have considered it at that point because they didn't have it.
Right. I don't, again, I go back to my original thought, which is the planning board didn't necessarily need the Board of Health decision to make their decision, unless they were approving it. If they are going to approve this subdivision, then they couldn't do that unless they had the approval of the Board of Health before them.
So in
So
a,
it's a
in a
little,
nor-
yeah, it's a little circular, but.
Yeah, in a normal circumstance, which I know this one necessarily isn't,
Yeah.
if the plan that's submitted, you don't have the Board of Health approval or disapproval, doesn't it make sense to, maybe this is back to Justice Hodges' question, let's hold off on making a decision until we have all the information? Wouldn't that be the normal way to do things?
I don't know about normal, that might have avoided some of the problems or certainly some of the arguments and issues that have been raised. But that's not what happened. I mean, these are not professionals, these are townspeople doing their best. And they had already gone through a process. There was no indication that anything there, that any further tweaks that the engineers were going to give them on this particular day was going to solve their concerns, which were large and substantial. This is a problematic, marginal piece of property. They were very concerned about this going forward, and the standard is very deferential for a planning board. If there's any basis that they can raise for denial, it has to be supported, and I assert to you that's the situation here, then their decision ought to be undisturbed. Thank you.
Thank you. Thank you to both parties. The case is submitted. And at this point, this concludes the sitting of this session. I want to thank all of the court staff, its efforts for making this session possible. Thank you.